the Honorable Amason Kingi, Speaker of the Senate, the Honorable Kathuri Moronge, Deputy Speaker of the Senate, all honorable members of the Senate, the clerk, very distinguished ladies and gentlemen, good morning. My name is Martha Koome. I'm the Chief Justice of the Republic of Kenya and the President of the Supreme Court, and it is indeed a great honor and privilege for me to join you at this induction retreat for the 4th Senate of the Republic of Kenya. Allow me to congratulate you, all honorable members of the Senate, on your election or nomination as members of the August institution, which is a vital pillar in the protection of our system of the devolved government. I also take this opportunity to wish you all the best as you perform your roles. Allow me also to convey my heartfelt congratulations to Honorable Amason Kingi and Honorable Kathuri Moronge upon their election as Speaker and Deputy Speaker of the 4th Senate, respectively. Honorable Senators and Speaker have been invited to speak on the topic, the Senate and the judiciary, reflecting on emerging jurisprudence on Kenya's devolved governance. I will share briefly the jurisprudential experience from the Supreme Court of the Republic of Kenya on the role of the judiciary to give effect to the constitutional governance and architecture as anchored under devolution, by stating clearly that devolution is a principle in the Constitution whereby we are all enjoined to promote and protect. Central to the project of state building are courts and constitutionalism. Kenyans chose a path of constitutionalism and following the rule of law in all the things that we do. Courts are therefore an emerging constitutional democracy like ours, required to serve both as protectors of the Constitution and also to perform our constructive role of ensuring that we breathe life and spirit to the Constitution all the time. In the court's protective capacity, honorable members, courts serve to defend fundamental elements of the constitutional order from being altered or destroyed. In such contexts, such as ours, with a history of authoritarian rule, which is also characteristic of many fragile African democracies, judicial review reinforces democratic governance by safeguarding core structures of democracy from being eroded. Thus, with respect to the constitutional project of devolution of government and bicameralism in the legislative system, our courts serve a protective role by guarding the institutions established to engender the project of the devolution of governance. The courts, therefore, are the foremost to defend the devolution. In every instance where devolution has been threatened, the courts have listened to the calling, and specifically the Supreme Court has stepped in to defend the spirit of the devolution. I will illustrate this point with two landmark decisions. One in the case of the Council of Governors and 47 others versus the Attorney General and 3 others interested parties, Katiba Institute appearing as amicus curiae. On the 15th May 2020, the Supreme Court rendered an advisory opinion on how the recurrent failure between the Senate and the National Assembly to agree on the division of revenue bill would be resolved. The court directed that funds equivalent to 50% of the previous year's allocation should be disbursed to the counties whenever the legislative chambers have not agreed on division of revenue between the 2 levels of government, despite the commencement of a new financial year. This recurrent stalemate has often led to delayed disbursement of funds to the county governments and thereby impacting very negatively to the delivery of services by the county governments. In an earlier decision, in the matter of the Speaker of the Senate and another, versus the Attorney General and others in 2013, the Supreme Court gave an advisory opinion that the Senate has a clear role to play in processing of the division of revenue bill. This was in the face of assertions by the National Assembly that the Senate should not be involved in the processing of the division of revenue bill, which is the legislative instrument for budgetary allocation between the National Assembly and the county governments. And more recently, Mr. Speaker and honorable members of the Senate, in the CDF case 2022, the Supreme Court held that it is unconstitutional to allocate funds to the CDF before the division of revenue between the national and county governments. In addition, it was the position of the Supreme Court that the CDF offends the division of functions between the national and county governments to allow a CDF an instrumentality of the national government to undertake functions devolved to the counties. This clearly underscored the separation of power and that delivery of service is devolved to the county and the constituency is subsumed within the county just the same way as the ward is. There is also a constructive law for courts which involves building and developing the foundational principles of an emerging constitutional order. In aspiring democracies like ours, judiciaries have the potential to build a culture of constitutionalism. While its protective role focuses on the existing structures of constitutional governance, this facilitative role is expressly forward-looking as it calls on courts to be conscious about crafting principles of constitutionalism and protection and promotion of the human rights, and also a rights-based approach to all the things that we do. We must inbuild a rights-based approach. In reaching for judicial tools to employ in discharging these constructive roles, courts use an interpretive approach that promotes and gives effect to the foundational values and principles of the Constitution. In addition, the courts use purposive interpretation to incrementally develop the law over the time. In the context of the devolution of governance, the Supreme Court of Kenya has similarly played a constructive role by developing jurisprudence that enables the institutions established under the devolved system of governance to operate effectively. In reference, Speaker, County Assembly of Embu advisory opinion, which was rendered on 9 March 2018 on what ought to happen when the office of the Deputy Governor becomes vacant in the absence of a legislative framework on how to fill in the vacancy. The Supreme Court, in yet another landmark decision, adopted the approach that the law is always speaking and advised that where a vacancy occurs in the office of the Deputy County Governor, the Governor shall within 14 days nominate a person to fill that vacancy. The County Assembly shall vote on the nomination within 60 days after receiving the nomination from the Governor. Where a vacancy occurs in both the offices of the County Governor and the Deputy County Governor at the same time, the office of the Deputy County Governor shall remain vacant until the election of a new Governor. The new Governor shall nominate a person to fill the vacancy within 14 days after assuming office. The County Assembly shall vote on the nomination within 60 days after receiving it. This wording applies in all circumstances pursuant to which the office of the Deputy Governor may become vacant as contemplated in the Constitution, and this may happen on death, resignation, or impeachment. I also wish to share with you, Honorable Speaker and members of the Senate, another decision of the Supreme Court in the case of Base Titanium Limited versus the County Government of Mombasa and another, where the Supreme Court delivered a judgment addressing the question on whether it is proper for a county government to levy a road service charge for a road that is vested in the national government. The court found there was a distinction between national roads and county roads. National roads were maintained solely by the national government through Kenya, while counties maintain their roads in collaboration with other authorities. To access the port, the appellants, Base Titanium, and to use the Likoni-Ukunda Road, which the Kenyan road system identified as a A14 road. A A14 road fell directly into the category of the national roads. That category fell directly under the mandate of Kenya and the national government, which oversaw its development, rehabilitation, management, and maintenance. It was therefore the decision of this court that the national government was the provider of the road service in this case. Should an access fee owing then be the proper entity to which the amount was owed, be the national government or the county government. This decision that I've highlighted show that the judiciary generally and the Supreme Court in particular, we are developing rich indigenous jurisprudence that has protected the spirit and the tenure of devolution, and this has also enabled the devolved institutions as established under the Constitution to function optimally. The courts have done this by adopting a purposive approach to constitutional interpretation. As I conclude, Mr. Speaker and honorable members, we should always appreciate that ours, democracy, and our institutions are still fragile. They need nurturing, they need support so as to recharge our responsibilities and so as to develop systems and structures that can withstand all the times and all the regimes. We must therefore work to serve our people and realize the promises of 2010 Constitution. After all, we all serve the same people. If we are in the executive, if we are in the judiciary, or if we are in the legislature like you are, we all render service to one Kenyan, who we fondly refer to as Wanjiko. When Wanjiko is suffering for failure of a system and failure of delivery of service, it doesn't matter whether the Senate has done its work optimally, whether the executive has done its work optimally, and the one who is failing the Wanjiko is the judiciary. All of us fail. So we must pull together, and this is why we maintain within the judiciary a very vibrant interaction with the stakeholders through the National Council on the Administration of Justice, and also at the court level, at the county level, at the service delivery level. We have the court users committees, which I urge all of you to take an interest in, so that as stakeholders we can feed one another with the best way in which we can deliver our services to our people. Once more, I take this opportunity to thank the Honorable Speaker for inviting me and giving this opportunity to interact with you during your induction workshop. I wish you all the best. Thank you.